This is a topic that I think is quite critical in our culture today, and I have talked with our speakers numerously about how to address it, and they're going to give us a tremendous overview, and they're going to be very specific as well as to what we can and can't do as people of faith in the marketplace for people who own their own businesses, and many of you here do, or for people in management positions that have HR responsibilities. So thank you for coming, and I think we're in for a real outstanding morning. We're getting a little bit of a late start. We had hoped to start right at 9, and I might finish about 9:05. So if we go a couple of minutes over, that's the reason why, but it won't be more than 5 or 10. I'd like to first of all thank our staff, our team at Needle's Eye. We have been looking forward to this, as I said, for over a year. And a lot of people put some time and effort into this. So when I call your name, just wave, let people see who you are. I think most of us are here today. I want to start with Jordan Maroon. He is our new executive director, and I'm really excited that he is. So he's over there next to the wall. Jeremy Woltz, he is fairly new with the team, and he is our director of discipleship and small groups. The gentleman you met coming in is Michael Ferreira. He is our manager of operations in finance, and I don't think Roxanne Crosby is here. She's an outstanding volunteer. But our communications consultant, James Lee, is right there, and we consider him a part of the team because he is. And last but not least, the lady who is not here because she's holding the fort down on Barrington Court is Pam Paget. She's our administrator and has done a phenomenal job in these last months getting us ready for this event. So I would appreciate it if you'd give our team a real round of applause for all they've done. So we have two outstanding attorneys that are going to speak to us today, and you've seen the promo, so I'm not going to go over the title or whatever. You know they're from Sands Anderson, which is an outstanding firm here in Richmond, and many of their people are involved with Needle's Eye. But I want to tell you a little bit about each of our speakers. Give me just a moment because I want to hit some things that I think are important, so it might take a couple of minutes to introduce them. And there might even be a little bit of humor in the midst of it. So, Brian Muse. They're both from Tidewater. Brian Muse, his legal strengths lie basically in both litigation and in counseling. He has experience representing clients in labor matters, including unfair labor practice charges, before the National Labor Relations Board, as well as union grievances. He also provides on-site training and seminars related to anti-discrimination and anti-harassment policies to help businesses stay on track, and I love this, come out ahead. Brian is married to Jennifer, and they have two boys, 16 and 10. He has represented businesses in employment and discrimination claims in federal and state courts, including matters before the Federal Courts of Appeal and the Supreme Court of the Commonwealth of Virginia. He was named one of the best lawyers in America for employment law and management in 2019 through 2022. Brian, I'm excited about the fact that you can get ahead of the calendar for a year. I'd like to know your secret to that at some point in time. He also named one of Virginia's super lawyers for employment and labor law, 2019 through 20, and was named by the Virginia Business Magazine to the legal elite in labor and employment law, 2012 through 2020. He has an undergraduate degree from the University of Virginia, and his Juris Doctorate, I think I'm pronouncing that correctly, is from the Marshall Wythe School of Law at William & Mary. Among his many community involvements, he is on the board of Avalon, which is a center for women and children, and he also, and this is what he told me today, first thing out of his mouth, I'm involved with the Williamsburg Youth Baseball League as a coach, and I've just heard him talking about the Atlanta Braves. We haven't talked about the Red Sox, but we had a good season, even though we didn't make it to the series. Our other attorney is Robyn Hansen, also from Sands Anderson. She is a seasoned attorney who brings over 35 years of experience helping employers meet a wide spectrum of their legal obligations. Robyn, I have you about 10 years, so I hear you saying, wow. I've got more than that. Not as a lawyer. She's a strong advocate representing her clients in claims filed against them in federal or state agencies or in state and federal court. Whether she's supporting a university or advising a medical institution or beyond, Robyn provides legal representation and support in addressing issues arising in the employment context, such as discrimination and harassment claims, non-competition disputes, defamation claims, and wrongful termination claims. Outside of the office, she has been married for 33 years to her husband, Paul. They have 3 children. They're adult children, Kristen, Lauren, and Nick. She enjoys reading and writing and often uses her writing, and I found this quite interesting, often uses her writing to help and encourage others in their spiritual journeys. Professionally, she has experience as a litigator in both state and federal courts at the trial and appellate levels and on a myriad of employment cases. She has extensive experience representing employers before various governmental agencies such as the Equal Employment Opportunity Commission and the Department of Labor, among others. She was also named Best Lawyer in America at the Best Lawyers in America list in employment law and management. Again, creative. Sands Anderson must have some issue and some answer here because this was for 2022 as well. I want to know how you do that. She also was named to the legal elite through the Virginia Business Magazine in the category of labor and employment law for 2005 through 2007, 11 through 13, and 16 through 20. What happened to 15?
I don't know.
Okay, all right. She has her undergraduate degree from the College of William & Mary in history and economics, and her Juris Doctorate as well from the College of William & Mary's Marshall Wythe Law School. Her community service includes, and there is a list, 2 of the things I picked out to share with you, I thought you'd be interested in. She is a former past president, vice president, and secretary of the YMCA of the Virginia Peninsula's Board of Governance Committee. She also is a former board member of the City of Newport News Retirement Plan and Health and Welfare Plan Board of Trustees. I think we're in for a real treat. Would you help me welcome both of our speakers, Brian Muse and Robyn Hansen.
All right, does this still work? Everybody hear us okay?
All right.
Well, thank you so much for having us. As Buddy said, this has been a program. I might need this at some point. Buddy has said this has been a program which has been about a year and a half in the making. It was kind of putting this together is sort of for all of us. Robyn, Buddy, me has really been an act of love and perseverance. Having to postpone it not once but twice during COVID. And, as we were, I think I was, saying, to David Carroll a few moments ago, the really great thing about what I hope is our presentation is sometimes, to be candid, when you have presentations that get postponed for whatever reason, there's a little bit of a fear of, is this going to be stale? When I finally do this, are people going to say, yeah, you meant to do this a year ago, we can tell. But the great thing about this, I think, and obviously you all will be the jury on this when we're done. But the great thing about this is that as we time went by this past year, and as we were preparing this, I think Robyn and I both felt that, we were really blessed doing this in that it's became more relevant and it's become more current as the months, and even year has gone by. So, we're real excited, and we hope there's, a lot of good content, both that might engage you intellectually in terms of thinking about these issues, as well as some practical aspects, which, hopefully when you leave, provide some good practical guidance. So that's us. We're excited to be here. Again, I don't know that I can up anything Buddy said in terms of my bio. I really, and this is a topic I'm very passionate about. So excited to be here, Robyn.
I've No, I think Buddy did it well. It is a topic I'm very passionate about, and let's talk about it. Faith and free exercise and the intersection in the workplace. What does that mean? I mean, and as Brian said, because this topic, let's make sure I'm working right. Can you hear me? Yeah. Okay, good. Because this topic got put off, it actually became more relevant, as Brian said. And things continue to happen in the world of COVID, brought religion and the government and employment all together for the first time. And there's been some developments in laws that we'll talk about later today because of that very fact. So as we get started, what are the laws impacting religion in the workplace? We have the First Amendment, and I'll talk about that in a minute. Somewhat yes and no, the First Amendment. And we have Title VII of the Civil Rights Act. That was passed in 1964. It was amended in 1991. And that protects employees on the basis of religion. Employees can't be discriminated against because of their religion in the workplace, and among other different categories. And then we have the Religious Freedom Restoration Act of 1993. It's not directly in the employment arena, but it does have an impact, and it has an important impact. And we want to go through all of these today. And these are federal laws. We're going to talk about state laws too. There's some state laws that come into play, and there may be a collision between the state laws and the federal laws at some point under this Religious Freedom Restoration Act that we'll talk about.
If you've heard of RFRA, if you heard that term, the statute was passed in the early 90s, signed by Bill Clinton. But just, if that rings a bell, hearing about this RFRA statute that protects belief, that's what this one is. Right.
So let's, you want to click on to the next one. So what's the First Amendment? You hear the First Amendment everywhere. We hear it representing employers. We have employees in the workplace who say, talk about the vaccines. I don't want to get a vaccine because it violates my First Amendment right. Well, I'm here. Let's get something clear. The First Amendment, and we have it quoted here, it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And then there's the rest of the First Amendment. But those two religious clauses, that Congress, the government, will not establish a religion or will it prohibit the free exercise of a religion. But if we move to the next slide, it's important to know that what does the First Amendment do? And this is what we all need to understand because you hear it thrown around everywhere. Everybody says, this violates my First Amendment right. The only entity that can violate your First Amendment right, technically, is the government. Federal or state governments can violate your First Amendment rights, or you're protected. They can't violate it. They're the ones, if a federal or state government takes an action, you are protected by the First Amendment. If your private employer takes an action that prohibits your speech, depending on the circumstances, there may be no violation of your First Amendment rights if it's a private employer. And we're going to talk about that later today. But I think it's important at the outset for everybody to understand that the First Amendment, it prohibits the governments from taking actions that inhibit your rights. It doesn't prohibit me from telling you I disagree with you on something. It doesn't prohibit me from violating your First Amendment rights. Hopefully I wouldn't do that, but it doesn't prohibit me. So it doesn't necessarily apply to private employers. And I think that's a big lesson because we hear it so much. And so now we're going to move on to Title VII. And Brian, you want to start talking about Title VII?
Sure. Title VII, when it comes to religion in the workplace, and we're going to really kind of get in the weeds on a lot of this as we move forward this morning. But really, if there's one statute, if there's one law, because, while we're going to get into a lot of which I think is some of the fun stuff in this, I think really the best place to start, like anything else, to kind of give you the lay of the land, what are the rules? And so we're kind of starting with the back of the Monopoly box, what are the rules that apply to all this, what's the framework? And for employers, for employer-employee relationships, really that begins with Title VII of the Civil Rights Act of 1964. As Robyn said, it's been amended, but as with a lot of federal statutes, and we'll get to this, really where the ebb and flow and the pull is not so much with amendments, because, I don't think I'm saying anything particularly controversial, even on video, that, Congress is not necessarily the most nimble in terms of getting things done, getting legislation passed, things like that. I don't think that's shocking for anyone to hear. But usually where we see changes in this and developments are on the administrative side. We'll get in this a little more, but Title VII is administered by the Equal Employment Opportunity Commission, or the EEOC. And of course, the EEOC has its own guidance and its own regulations. Now, in theory, that guidance should come from the statute, right? And it does, but what we find representing employers is that, where the EEOC and its regulatory guidance goes with some of the gray areas or some of the uncertainty is heavily dependent, obviously, on politics. That's actually what attracted me to doing employment law in the first place. I was a government major, and politics has always been an interest of mine. And, frankly, employment law is a real political animal. I think you see it's one of the few areas where you turn on the news and, you're talking about, employment laws and these statutes. So back to Title VII. What is it? As Robyn said earlier, it's a civil rights statute. It really grew out of, 1964, the 1960s civil rights movement. Which I wasn't born in 1964, but if you were around watching the news, the driver of the civil rights statute was race discrimination. That's what was, just like that was the lead on the and that's what everybody was focused on. It was meant to prohibit and protect race discrimination. That's what pushed it through. That was really its purpose. But of course, it's much broader than simply prohibiting race discrimination. It has a whole litany of protections. National origin, that's the statute that prohibits sex discrimination or sexual harassment in the workplace. And for our purposes today, discrimination based on religion. In order to fall within the ambit of Title VII, in other words, in order for someone to say, I'm filing an EEOC charge against you because you violated Title VII as my employer, the employer has to have at least 15 employees. And again, it prohibits discrimination on the basis of religion in all aspects of employment, whether it's harassment. Robyn's going to talk about accommodating religious issues in the workplace, or just discrimination. And as I mentioned earlier, it also provides a requirement that employers have to provide religious accommodations to employees, so long as they don't pose an undue hardship on the employer. Title VII, in terms of liability, it goes towards the company. It does not have a manager or employee liability arm. In other words, if an employee believes they were discriminated against, their remedy is to file a charge against their employer, i.e. the company. All right, well, obviously we're here to talk about religion in the workplace, so while I wanted to make sure everybody had a sense when we talk about Title VII as breadth, we're really going to hone in on religious protections under Title VII. Again, protects employees from religious discrimination in the workplace. And this is where, as Buddy mentioned, a lot of this, I don't want to call it confusion, but sort of tug and pull, what can we do and what can't we do? And it's interesting because there's a lot of tension in some of these laws. And I know I'm not just going to kind of read the PowerPoint. Everyone can do that. But I would really sort of hone in on kind of the middle of this slide where it talks about employers may not prohibit an employee from exercising their religious beliefs in the workplace unless the conduct interferes with job performance or causes undue disruption in the workplace. And that also applies, for example, a manager or an owner. Even though they aren't necessarily, someone that you would think would bring a claim, they're also covered under Title VII, or certainly a manager or, an executive. And they also have the ability to, exercise their religion in the workplace. Some examples. Wearing religious clothing or jewelry or items, listening to religious music. Obviously, the caveat there is in a situation where other employees are entitled to listen to music. I use that as an example just because it actually comes up. Because a lot of times what we find is employers, religion in the workplace makes them nervous. And there's often a push, the best thing to do is just tell anybody none. We don't want to hear anything about religion in the workplace. Yeah, we allow people to listen to music at their desk. You can listen to your music. Oh, you want to listen to, Christian spiritual music? You can't. And they think they're protecting themselves, i.e. because they're, keeping it out of the workplace. Well, what we're here to tell you is you can't do that. That would be a violation of Title VII because it would be discriminating against an employee kind of on an equal basis. In other words, you're not saying if an employee says, well, when I'm talking to customers, I'm a waiter and I want to have my music blaring when I go to the table. Of course not. Because you wouldn't let anybody else do the same thing with their music. But where you have conduct which you're allowing in a secular capacity, you can't prohibit it in a religious capacity. And this is another issue, I think, which can be very complex for employers. You also can't prohibit employees from speaking about or communicating about their religious beliefs in settings where non-work communication is appropriate. Yes, an employer can say to an employee, look, we're trying to get this presentation out the door. We have an hour. This is what we need to focus on. Just like you would, Brian, you can't be talking about the Atlanta Braves for the next 45 minutes because we got to get this out the door. But you can't, at the same time, an employer can't say, or an employee can't insist on an idea of, no, I don't want, when I'm in the break room, I don't want a coworker or frankly even a manager or a supervisor, talking about religious topics, if it's in a setting where non-work communication is appropriate. That is allowed. Now, the devil often, no pun intended, is in the details with some of this. Right. And that gets us to, that third kind of bullet and sub-bullets. One, I'll get to the second one first, workplace disruption. I've kind of hit that. Certainly employers are entitled to run their workplace in a way that accomplishes their business interests. I mean, that's why the employer exists. So an employer certainly can put neutral policies in place, which allow the business to function without disruption, function smoothly, allow the accomplishment of their goals. What really interests me, and this is really kind of this intersection that we're talking about, is this. I got a fancy light. I'm going to use it here. Claims from coworkers of harassment or discrimination, and this is where it gets interesting. We talked about, and everything I've said is 100% true. Robyn would have certainly said, no, don't listen to him. He's wrong if I was telling anything that was way off base. But you also can have a situation where you have an employee says, gosh, I'm offended, based on whether it's their own religious beliefs or their non-religious beliefs. And I'm upset that this person's talking about religion in the workplace. And I feel like that's discriminating against me. This person's trying to convert me. I'm discriminated. I'm the only person of this faith here, and this person's trying to convert me. And those become really tricky situations because, as I said, as an employee, you have a right to exercise your religion. As a manager or supervisor, you don't have to, I sort of use, you probably heard the expression in the school context where they say that, students, you don't leave all your rights at the door of the schoolhouse, when you go in terms of, free speech and things like that. Just because you're an owner or supervisor doesn't mean, you can't, be you and express yourself. But you do run into these problems or issues where you have this tension between an employee that feels they're being discriminated against based on religious, talk or action in the workplace versus somebody's exercise of their religious beliefs. And that's really the tension. Robyn, you want to?
Yeah, well, I was just going to say, and the issues that you really have to worry about is the manager, supervisor versus the mainline employees, because the manager supervisor is in a position of power. And if that manager supervisor is deeply religious and has a desire to convert all their employees, that can become very dangerous. So it's a balancing act that you certainly have the right to express your religious opinions, but only so far as you don't make an uncomfortable environment for other employees, particularly those who have less power than you or in a lower position.
Yeah.
And we have a question.
Yeah.
About the creating a uncomfortable situation. So that sounds like quite the gray area. Is there some kind of line where we can?
No, I wish I could give
there's
I wish
no
I could-
line. There's no line. Usually the advice I give here is it kind of turns on coercion.
Right.
I think the reality is this, kind of giving you the lay of the land. If you're doing something that would be viewed as coercive, like I want to sit down with you and tell you about my path to Christ and why I think you should be on that path and you're on the wrong path. And the key here is not so much just that conversation, but then let's say 2 weeks from now, that employee gets disciplined or terminated. And you're going, well, this is completely unrelated to that. They were disciplined because they messed up this assignment. Then they turn around and say, wait a minute, it was because I didn't convert to my manager's faith. So I think where there is a realistic possibility of somebody making a claim based on coercion, I think that's where the trouble hits. I don't think it just, Robyn can speak to this too. She may have a different opinion, but I don't think passive things bother me in the same way. Like I'm not worried about somebody saying, well, I'm of this faith, but my manager, he has, something religious on his wall or something on his desk, and so, that offends me or something like that. I don't think that gets into the line.
Right, I don't think that gets in the line. I think it would, my recommendation in the environment that we live in, if you're not in a entity that will qualify as a religious organization, if you're a manager, supervisor, I would not recommend proselytizing or other employees in the where you work. It's just inviting trouble. You can certainly, St. Francis says, let my word, I don't know. People quote it. I don't know if anybody can find out that St. Francis really said this, but I understand that it's my actions speak louder than my words. Let people know who I am, not what I say. And so if you live the Christ-like life and you show by your examples your compassion and then they say, well, why are you this way? Then you can say, well, Christ is in my life, and you can proceed from there. But let your light shine in the darkness.
Yeah, we got some more. I want to go, I think you had the hand up first, if you want to.
Well, I guess because I'm a manager in my office, and I want to be very careful with my team. They don't feel any pressure whatsoever. There was an employee from another team, but we're in the same larger unit, but he's under another manager. And he and I went out after work and chatted a little bit. And I think it would probably be okay to maybe make an observation that would be thought-provoking. for that person to think about, but leave it there. You know what I'm saying? In a non-work setting, perhaps. But I agree, maybe if you're a manager, you don't do that with anyone, whether they're under you or not. I don't know. So.
I mean, I err on the side of caution myself. I mean, I do a lot of Christian things, so my people who work for me know that the things that I do when I go out, and so I go to a meeting at a church, I do this ministry, so people know that, but I am very cautious about any type of expression of you should do this or you should do that you should stay away from completely.
But you don't have to hide.
Right.
I think that's because I know that one thing I've been very focused on, and that Robyn and I have been very focused on preparing this presentation, we get this isn't just meant to be kind of a training, just stay
Right.
away from it. That there's a lot of curiosity and interest. It's like, look, we really want to know where the lines are, where they exist. Obviously, sometimes your point, we can't say here exactly where it is. But, I think that best advice I can give is, avoid anything that could be perceived as coercion, but you don't have to hide. I mean, if you're
Right.
going to a Bible study, if you have to leave at 4 for a Bible study, you can say, I'm leaving at 4, I have a Bible study. You don't have to make up and say, I'm going to a basketball game instead of a Bible study to hide the fact that you're going to a Bible study. But just, I think cautions, is prudent. And just think about, my litigator's mind, I always say, think at the end and go back. If somebody's on the stand saying, this is why I felt coerced. I mean, if all they're going to say is, on the way out the door, she said she's going to a Bible study, that's not going anywhere. But if they're able to say, well, they told me I should do X, Y, Z, then lo and behold, 2 weeks later, I was fired or I was disciplined. Different story. We have questions here? Yeah.
Yes.
Yeah, go ahead.
I wanted to state that I was in a position once, I was a CFO, my boss is CEO, we were preparing for a board meeting, we get there early, and he walks in, and he thinks he's joking. And he says, those earrings will get you written up. Well, HR's under me. He thought it was a joke. I had on little cross earrings. But I was offended.
Understandably.
Understandable.
Yeah,
Yes.
I stopped wearing crosses to work for a number of years because I was thinking, why would he even say something like that to me? And I never brought up Christ overtly. And that was, to me, an example of someone just not being careful or paying attention to what they should have said, or not said in a business environment.
I will answer that probably as starkly as I can. I think it comes from maybe a lack, either, I'll give the person the benefit of the doubt that it wasn't meant mean-spirited. So I'll say that charitably, I'll say that I think it probably comes from really an ignorance and a lack of understanding of the law. Maybe thinking, oh gosh, we could get in trouble in some amorphous way for someone having religious symbols. But let me...
It was my job to keep them in trouble.
Exactly, but under Title VII, and I'll be as stark as possible here, that comment was no different than a similar comment about race or sex or, you being from China, that'll get you written up around, those comments under Title VII are no different. So, I think that's where a lot of the education in this area comes from, because I think that there's a lot of confusion under Title VII when you get to religion.
Well, I agree. There's a lot of confusion, and there's an overreaction to religion. I mean, people overreact to everything, and in the Title VII context, religion has become a taboo in the workplace, and so you can't talk about it. You can't have anything to do with it, thinking that it violates the law. They want to, sterilize the work environment, but that's not the law. But there is that gray line, there's no litmus test. And so you have the right to express yourself, but your expression can't interfere and make someone else comfortable.
Yep.
The last example for Jerry was, as Christians, we know each other as Christians, and I went into the restroom and one of my Christian coworkers were crying. And she asked me to pray for her, and absolutely I did.
Mm-hmm.
You know, that is no coercion of pressure or
Right.
or
Agreed.
anything like that. It's
Perfect.
acceptable.
Yes,
Okay, right here.
the
Yeah.
beard.
My question has to do with companies that are established on Christian principles,
Great.
like Chick-Fil-A,
Yeah.
My Pillow.
Right,
Hobby Lobby, yeah.
yeah.
When you're a Christian business owner and you establish your whole foundation, your structure on Christian principles, and prior to hiring, people know this is what you're coming into. How does Title VII protect the owner, but also?
That great question.
And fortunately for you, can you put a pin in that, because that's a big, because that's where we get past this.
We're gonna talk about
I mean,
that.
that's going to be a big. I mean, you hit the nail on the head of one of the big parts of this presentation. So why don't we kind of move through, kind of the lay of the land. Again, I don't want you to think I'm avoiding your question. I think we're going to spend
We have
probably
some-
40, a lot of time on that question. There's one more over here.
Same question.
Okay, yeah.
Okay, well, we're
Good.
gonna move
We're it's coming.
It depends, all right.
Yep, I moved the slide. You're
Yeah,
good.
we need to move the slide.
No, I did.
Oh, a comment. Oh, okay, sorry. I didn't even see it. Okay, so we had said earlier, and I talked about, and I have worked tremendously with the vaccine issues. And I have worked with employers who have developed vaccine policies and requiring mandatory vaccinations. We know it's coming down from the federal government.
Not to interrupt, Robyn, but breaking news. I haven't looked at it, so I know no more than you do, but learned literally while I was eating breakfast that they have put out the large employer, 100 employer mandate. There was the press conference, so we knew it was coming.
Right.
But they released the rules today. So
we heard that
yeah.
on Monday it was
Yeah.
coming. So,
Yeah.
okay, so it has come. So we're going to have to go back and read those and see exactly what they say for the large employers, because we've all been wondering to whom and who is a
Yeah.
large employer, whether governmental entities are or not. But the religious accommodation rules developed a long time ago. And they didn't develop in the context of vaccine mandates. It has been used over the years for the flu vaccine. Hospitals have required flu vaccines and gone through this request for exemptions. Also, elementary schools, colleges and universities, for students to become enrolled, they have to have had certain vaccines. But basically, the rules developed where you had a Jewish employee, Orthodox Jewish employee, who didn't want to work on Saturday, their Sabbath. Could the employer accommodate that individual? And so that was one way this line of cases developed. As I said, there were some flu vaccine cases, but not as, it still wasn't a big focus. You also had the question of the Muslim woman who wanted to wear her hijab to work. Could the employer accommodate? Those were the types of questions that the laws developed under. Then we were hit with COVID, the vaccine mandates, and no pun intended, but a lot of people got religion for these vaccine mandates. It was incredible, the questions that I have received through this process. But under Title VII, to get an exemption or to get an accommodation, there are three things that for the exemption to actually be granted and reasonably accommodated, or the request, the accommodation to be granted, is it has to be based on a religious belief. Now, what is a religious belief? It doesn't have to be based on a standard, typical, recognized religion. You don't have to be Methodist, Episcopalian, evangelical, Seventh-day Adventist, or whatever. It can be an unrecognized religion, but it has to be a core fundamental thought about life and death. It's not political, it's religious. So Brian mentioned the EEOC. The EEOC's guidance, I will say, has is trying to go further. It's an interesting tension the EEOC is having. They are trying to go further with a very broad definition of religion to encompass everything that a person thinks.
Philosophical, beliefs,
political, and it's not. It is, it's supposed to be core principles. The tension the EEOC is having is the current administration is pushing vaccines and pushing not to give exceptions. So the EEOC with the current administration has a tension going on, but they are having a broader definition than I think the courts have recognized or should be recognized. But it has to be based on a religious belief. So one of these core values. It's got to be critical to your religion, and it has to be sincerely held. Just because you can't say, today I am, Buddhist, tomorrow I'm Hindu, and, it's got to be, there. You have to see that the practice is sincere, it's core, it's critical to the person. And examples are making an Orthodox Jewish person require them not to eat kosher. That would violate their religious beliefs. But also, it can't pose an undue hardship on the employer. And what's an undue hardship? Now, Brian and I, as an employment attorneys, have dealt a lot with the ADA, the Americans with Disabilities Act, on what is an undue hardship. But we come back to Title VII and religion, and the courts have said, for the purposes of an accommodation under Title VII, an undue hardship is defined as something that requires the employer to bear more than a de minimis burden or cost. So what does that mean? That means that if the employer if it's going to cost the employer money, the employer does not have to accommodate that individual. The employer can say, it creates an undue hardship. That's not the same test for undue hardship under the Americans with Disabilities Act. Under the Americans with Disabilities Act, if you have to spend a lot of money, that's probably not an undue hardship. They look at the size of the employer, its resources, and so an employer has to spend more, is required to spend more on a disability accommodation than a religious accommodation.
In the ADA world is sort of, kind of the running kind of shorthand is, what a mom and pop, what's a hardship for a mom and pop isn't necessarily going to be a hardship for Microsoft.
Right.
Those sorts of things. But obviously, it's a different, as Robyn was saying, it's similar, but the devil's in the details, and it's very different.
Right. Yes, ma'am.
So you have lots of examples. So one example, working at the CFO at the Department of Aviation out at the Richmond Airport. When I started there, a lady already worked there who, we have jet fuel, we have a hangar. Governor flies from our spaces. But then she said it was causing her breathing problems and she wanted the ADA accommodation. So, I went and got a filter, I got the cost of what it would take to replace the AC, the windows, all of these things. And she still felt she wasn't accommodated. So then she had to take that further, but obviously we accommodated.
Right.
So that's another example.
Right. And so I have heard there was a group of nursing homes, and I heard that an attorney for or leader of a big, large group of nursing homes denied all religious accommodations for the COVID vaccine based on the direct health and safety of all of the patients in the hospital, and said, yes, you do have a sincerely held religious belief, and you're saying that taking the vaccine violates that sincerely held religious belief, but we can't accommodate that because of the health and safety of our patients in the nursing home. And that's so just to understand that just because it is a sincerely held religious belief, the employer can find, yes, I believe this person has a sincerely held religious belief, but it's an undue burden on us to accommodate that. And that becomes a tough question.
Yeah,
Yes.
and-
What?
What was the outcome of that?
As far as I know, no problems
Yeah.
for the employer.
Although it's still not the
Seven.
way that we normally like to proceed.
Right.
I'm a much firmer believer, in the accommodative area, whether it's the ADA or religion, that, an individual assessment's always best. Now, the reality is it may be that the individual assessment leads to the same conclusion across a broad category.
Right.
But I've never been a fan as an employment attorney of, we're just going to say we're not going to, we're going to put it in the policy that we're not going to accommodate.
Right. And I agree
Yeah.
with Brian
Yeah.
100%
Yeah.
because you do have to look at, take a nursing home. Are there employees in that nursing home who have no patient contact? If you have no patient contact, you can be in a private office, wear a mask. I've spent my life for the last year looking at all of these, but if you're going to be able to isolate, maintain, social distancing and not have interaction with customers or the public, then that should be looked at on an individualized basis. And I just gave that example as I was shocked, but that was, and I'd heard they'd been quite successful. But
I flipped it for you.
yes, so there is a statutory exception for religious organizations under Title VII. So it says this subchapter shall not apply to a religious corporation, association, educational institution, or society with respect to employment of individuals of a particular religion to perform work connected with the carrying on by such corporation, association, educational institution, or society of its activities. Now, it used to say of its religious activities, but it's any activities. So we can go to the next one. So a religious organization can include a broad spectrum. It's not just churches. It's not just entities that are designated solely to ministering. It's gone to societies whose purpose and character is primarily religious, as well as religious entities such as churches. Now, your question, does Chick-Fil-A, I'll give you a Chick-Fil-A, does Chick-Fil-A qualify as a religious organization? I'm going to say no. I don't think Chick-Fil-A qualifies as a religious organization that can take advantage of this activity. Now, there was a very interesting case. It was Mercy Health Services. It was held to be a religious organization exempt from Title VII, and that's a hospital. Okay, so I mean, you have Bon Secours, and they're all connected with Mercy Health. I was surprised, that's a long way from how it originally started. It was more like traditionally religious churches would get this exemption, or entities that clearly have their message. And there were questions about whether Mercy was would qualify as a religious organization. Its services that it provided were to heal the sick, and they tied that to their mission and statement. It's a Catholic hospital, and the court went through. There were crosses throughout the hospital. There were Bibles in every room. They had mass so many times a week, and that everyone knew Mercy's affiliations. So that court held that this religious exemption applied, that Title VII didn't apply to those religious corporations. So I think that's a big exemption, and it's an interesting one. And it's not just a church. So was found that Mercy could discriminate. So.
And the trend here, as we'll get into, is because one thing we always look at and what we do is kind of where are the trends going,
Right.
and the trend is clearly going in one direction right now. is going towards a broadening of the definition of religious organization. And as we'll get into in a moment, who even within that organization qualifies. We're seeing that we're seeing that at the federal court level, certainly.
So religious organizations, if you qualify as one, you can give employment preference to individuals based on religion. You can say you're required. Now, I work with a healthcare entity, and it's a free and charitable clinic. They were based on Christian principles, and to be employed by that entity, you have to sign their statement of faith, which is, you can be any form of Christian, but it's a statement of faith. And that's okay under Title VII, because they are a religious entity. And part of their purpose and mission, and that's important for you to understand, is if you're going to be analyzed by a court, what do your bylaws say? Do you have a mission statement? What are your policies and procedures state? Those are important documents that courts look at to determine, is this in fact a religious organization? And it's something for you to consider for the entities that you work with. Do you have a mission statement? Depending, how religious is your business to qualify for the religious organization exemption? And it extends to all services provided by the religious organizations. For example, in the Mercy Health, you had it was a healthcare provider who was, it was Tell Us Something, I can't remember exactly what it was, but it was not a doctor, but it was one of the staff. I wish I could remember what it was, but I don't remember right now. I don't think I could pronounce it either. But anyway, it was a healthcare provider's position, and that person was not wasn't a nun or a priest in the hospital, but that person provided health care. But the religious exemption still applied to them. So that's important, because that person was not necessarily involved in those direct Christian services or direct Catholic services, but they were related to the core services of that Mercy Health system.
And Robyn, I'll pose a question to you. You mentioned mission statements,
right.
Statements of faith, is what I went to say. If someone here, either it's the organization you're on behalf of, or we all know a lot of us wear a lot of hats. We are an entity, but maybe we sit on the board of a nonprofit, that's even more directly tied to our faith. When you're advising clients on, for example, we need a statement of faith, how important is it to be real specific in those statements in terms of?
I think you need to be as specific as your board can be, or as specific as you want to be. Because the statement of faith has to express who and what you are and what you believe in. And so if that statement of faith, you want it to be your statement, but you also want it to reflect the type of people that you want working for you, but you don't want to exclude others. I mean, I have been in questions about in board retreats, really looking at statements of faith. What is that statement of faith, and how far do we want to go so that all of our board agrees about what our statement of faith is? If you look at the discrimination rules, you want to make sure that your statement of faith will allow you to take advantage of exemptions like this one.
No, I think that's, my thought as well. The trick is, it's often maybe not a conflict, but a tension between, the business side's not the right word, but just kind of saying, we're not looking to stir things up.
Right.
Versus being able to, if it comes to it, protect yourself or your organization. For example, like a nonprofit, that has, maybe provides services. For example, like a, domestic violence shelter, for example, that, is a religious organization. And that's where the tension comes, because obviously normally there's a board and you're trying to get both, consensus, and also you're not trying to, a lot of times stir things up. But where the rubber meets the road is if you're going to say, well, let's just be generic and say, oh, we are based on Christian principles. Well, gosh, I mean, you think about the spectrum of people that would say, and I don't mean this negatively towards, I'm just stating this kind of matter-of-factly. Think about the spectrum of people that would say, oh, well, I'm basing what I do off Christian principles. I mean, it's pretty broad. So if there's something specific, whether it's, whether it's, some examples, for example, marriage, things of that, issues like that. The reality is, if you're looking and saying, this is a line we have, probably needs to be in the statement of faith.
But you have to be careful with those. And I just got out of a board retreat 2 weeks ago where we talked about a statement of faith and what lines you do and don't want to draw. If you go back to Mercy Hospital, for example, or they do in their guiding principles talk about marriage, abortion, issues that can go the spectrum of, a marriage between a man and a wife is, for some people, a fundamental principle of the Christian faith. There's another group out there who doesn't agree with that, and they could sign a statement of faith that they believe in Christ and Christian principles and have no problem signing a statement of faith like that. But so it gets into problems and issues about it's the elephant in the room, I've called it before. If you have one group over here that thinks that that's critical, that marriage is between one man and one woman, and you've got to make sure that that's all the Christians you want, and you're willing to put that out in your statement of faith, because you could get someone who doesn't agree with that, who can sign your statement of faith if it's not specific to those issues. But the question is, do you want to do that? I mean, I'm not advocating either, I'm not up here being an advocate of one position or the other. I'm just presenting that to you, that becomes a very sticky topic, but you and your board, your owners, all need to be comfortable. If you are a Christian organization, you want to take advantage of the religious exemption, that everybody, this is what we all agree.
Yes.
Yeah, our organization used to be, I'm a therapist, used to be Resource Guidance Incorporated. 6 years ago, the owner, and he and I talked about this, it was I did not like the idea. We changed the name to Christian Counseling Associates, and underneath it says a subsidiary of Resource Guidance, Inc. And I said, we need some type of thing in the waiting room to say who we are. And he says, oh, no, we don't. And I said, well, I mean, our sign says this on that side of the building. And we got 5 of these signs, all in the state of Virginia. So I'm not sure whether I'm right in this, but I think we need to have some type of statement in our waiting room as to who we actually are. If we say we are Christian Counseling Associates.
Interesting question. And so I pose another question to you, do you only serve Christians, or are you open to the public, but if you have to be employed with us, you're a Christian? They're two different questions.
If you're employed with us, yes, you have to be a Christian.
Do you have to sign a statement of faith, or?
Yes.
Okay.
The other part of that is I'm not sure whether the state of Virginia, when they give us a license, are expecting us to have a statement of faith on a wall. That's the other.
Well, if it's, I would say if it's, and I may be missing something, and Robyn can, certainly give her take. If the issue relates to employment, in other words, you will serve anyone that comes in,
Right.
Then I don't know that you necessarily have to have something up in the lobby.
Right.
Because that's more client facing, if you will. I think it's more important, that you have, and obviously I'm not familiar with the business, so, I don't have all the ins and outs, but just speaking generally, I think it's a lot more important that you have a statement of faith relative to who the counselors are and the employees and the therapists than necessarily, necessarily something in the waiting room concerning clients. I do think practically, it's important, obviously, if the spirituality of what you're doing is incorporated in the counseling, that's important that people know. I mean, you don't want someone in there going,
Absolutely.
I can't believe you just mentioned Christ in my counseling session, and you're going, sign on the door.
Yeah.
Exactly, but if they don't know that. So I do think practically, for your own good is probably, beneficial there. But, I think in terms of written things and things like that, it's going to be more important.
I don't think you have a legal requirement. If we're talking about employment laws, you don't. You have, your employees need to know, but it doesn't have to be put in your lobby. I think that becomes more of a question of your mission and ministry and what you want your patients who come in to see and know and feel. But I don't see it as a legal requirement from any perspective to have something posted in your lobby. And maybe, yes, Tom.
To follow up on that question, the gentleman with the beard, because I don't know this word.
My name is Steven.
Steven.
Steven's question. So suppose I'm manufacturing widgets,
Yes.
and which has no,
Right.
value other than it's a widget.
Yeah.
So I'm manufacturing widgets. But I want to be a Christian organization. So do I hear you saying then I would need a statement of faith and maybe bylaws, and so that I could?
Yes.
If I did all that. Let's suppose I'm very specific, and in fact, and I have a cross in the lobby, and we start every meeting with a prayer. We have a Bible study on Monday morning.
You're getting there.
Yeah.
So if I do all that, does that make me a Christian organization, and therefore I'm exempt?
That you have a good argument. Now, what Mercy Hospital had that you don't have is that healing the sick was critical to their they had a 501c3 status, which made the services that they provided, although non-Christian entities can provide those services, it was a charitable service. And so that's why I'm questioning Chick-Fil-A. I don't have the answer.
Yeah.
I don't have the answer. I don't say, and I haven't gone and researched, and someone may listen to this and say, well, didn't you know this court issued an opinion that Chick-fil-A could do what they did? I have a pause on widgets allowing you to take the full exemption, but I go back to RFRA, which we're going to talk about. May protect you. It's a really good question that you asked.
And as we're,
I'm just talking about employees.
No, and yes.
No, I know you're talking about employees.
And
that's why, and so you're just talking about, can you hire only Christian employees, right?
And they would sign off on all this.
Right. And so that would be taking advantage of Title VII's religious exemption to say you're a religious organization. And you've hit not one, it's not like a list of 10 and you have to check all 10. It's a whole factual circumstances, and you gave me a lot of facts that I think could go to say, yes, you can take advantage of
You
the,
could add some more if you want.
right,
The point is you would be able to sit down and check
Right.
it out.
right.
Yeah.
The question is,
And I think that you could, and I don't think that you have to be a 501c3 because we do have
No,
Hobby.
you definitely
Yeah.
don't. No.
Because you do have Hobby Lobby.
Yeah.
You're right. Chick-fil-A is not, and so I think yes.
Yeah, I think there's a sliding scale a little bit
Yeah.
in terms of also the size of the entity comes into play. Not directly. I mean, you're not going to, if anybody's kind of fact checking me, you're not going to find something that says, oh, the size of the entity is one of the requirements. But I think the larger you get, I mean, if you're a big public corporation and it's like, oh, well, our primary goal is to maximize shareholder value,
That's a different
well,
story.
that's your goal.
But you have
yeah.
like a Hobby Lobby,
Yeah.
huge,
Yeah.
but closely held
Yes.
by a family. Yes, David.
Yeah, real quickly, from a corporate law point of view, there's the new movement of B corporations. Have you heard of B corporations? B corporations have, under the imprimatur of the state laws, you conform to have something in your articles that say that you serve interests that are other than your shareholders, which was an anathema under normal conventional
Right.
corporate law. Everything was done for the profit motive, for the benefit of the shareholders, but now you can serve environmental causes and different causes like that, and you put that right in your charter. And the state of Virginia just recently, not recently, but a couple of years ago, passed the B corporation. And I think most states in the union now have, and a majority of states have the B corporation. So you could be known on the books of that state as having other agendas that are recognized, and you can do other things with your money. So I don't know
Yeah.
if that contributes
I think
to
it-
the argument.
I think
That's
it does.
a great point, and I think. Sorry, Robyn.
Go ahead. No.
I was going to say I think, and there's a couple slides on this. Not that I didn't beat you to it, but where we talk about the state needing to be neutral, and that's something we're going to get into. And generally speaking, if there's a recognition, for example, of, say, secular interests. Okay, you don't have to maximize shareholder value as just making widgets. You can have your, environmental justice or something like that. I don't think the state could say, well, these are fine, but anything religious isn't, because
Right.
then you're exhibiting a hostility towards religion.
Absolutely,
And we're going
I
to get
agree.
to that more
Right.
here in a second once we get through. Am I talking about ministerial exception or are you?
I thought you said you wanted to, but I'll be happy to.
Oh, I would love to.
Okay.
Because it's one of the more dynamic areas of the law of Title VII. Ministerial exception, generally what sounds like what it says. I mean, the idea is if somebody's a minister, they can't bring an employment claim. You're an exception to Title VII, as well as all these other statutes, Equal Pay Act, age discrimination, Americans with disabilities. This area has done an incredible transformation under the law. It used to be, and this is why I kind of led a little bit with Title VII, saying that while the statute is not amended every couple years, court cases, federal court cases, as well as EEOC guidance really shape it. And this is an area where we've seen some of the, really a lot of dynamism in this. It's really been dynamic, because what we've seen in a lot of, particularly out of the federal courts, is an expanding of who qualifies as a quote-unquote minister. For example, if, say a Christian school, it used to be the idea is you got to wear the collar, right? It's the guy or gal, wearing the collar. Now is expanded, anybody, say, teaching would be, even if they're not teaching religion, because it's part and parcel to kind of the mission, and they're carrying out the mission of that organization. So we've seen, really an incredible, it's not unlimited, but we've seen a really widening of the breadth of the ministerial exception within an organization. And now what we really look to isn't something so dogmatic as whether they're wearing whether they're preaching, whether they're a licensed minister, whether they're preaching, but are they really responsible for carrying out the work of the organization. You look at things, for example, are they customer facing? Do they have a role, for example, like a teacher or somebody who's interacting with customers or clients, as opposed to, somebody, maybe who's just fixing the computers, doesn't talk to anybody, doesn't, just fixes the computers or provides custodial services or something, where they're not necessarily carrying out the same mission. But really for our purposes, the ministerial exception, it's still called the ministerial exception, but it's a lot broader now than just faith leaders.
If you think about it, what the ministerial exception does, if we go back and remember, Title VII, I talked about there's an exception. So if you were a religious organization, you could discriminate based on religion in hiring and in retention. So, and you could say, only Christians come work here. And we got into the discussions of, what do you consider a Christian or not a Christian? We're going to get to that a little bit here too. The ministerial exception is much broader. The ministerial exception says that if someone works for me and they qualify for the ministerial exception, they're a teacher in a Christian preschool, and they say prayers with the kids and they teach them Bible lessons, then, and I actually had this case, I'm not required to hire a Muslim. I had a Christian daycare where someone applied and she was a practicing Muslim, and she filed an EEOC charge against my Christian daycare because they refused, well, not mine, but the Christian daycare I represented. And we won the EEOC charge under the Title VII exception because it was a religious organization, and this ministerial exception because this individual was not going to teach the preschool kids. So it's a perfect example of how you could extend the ministerial exception.
And want to hit this too, which I meant to mention. There's a sentence here, this exception is rooted in the First Amendment. That is extremely important. That may be the most important, sounds like a little wonkish technical point I'm making. It's not. So much of what we're talking about exception, some of these exceptions, accommodations, are statutorily written. And of course, two things on that. What Congress giveth, Congress can take it away. Two, it applies to federal laws. And one area we're seeing, and we're going to get to Virginia law here, but is an incredible expansion of state laws. Well, none of the federal stuff applies to that. But what does apply to federal and state governments is the First Amendment. And so when you have concepts like this that are rooted in the First Amendment, and, one thing we told Buddy is, we're not avoiding the gray areas here. Sometimes we do presentations, it's like, well, if I don't have a clear answer, I'm going to avoid it. But this is a battleground area, when you have a lot of states and, there's a whole spectrum of state laws across the country in terms of how much they want to recognize things like religious exceptions and accommodations, particularly where they confront other areas. We're going to kind of get to this. But if the First Amendment, if a federal court would say no, First Amendment applies to the states through the 14th Amendment. And if that means that things like the ministerial exception are part of a constitutional requirement, then your state law is going to have things like that apply too, or have that apply too, not simply whether it's in Title VII. So that's I think is going to be a really important area moving forward.
So let me finish, Brian, because I was in the middle of talking
sorry.
But that's okay. But here we want to
I got excited. I got really excited about the ministerial
Brian is
exception.
right, how important the First Amendment is to understanding this. Because if you go back to the other slide, what this means is that if someone qualifies for the ministerial exception and that person works for you and they want to bring a case against you under the Age Discrimination Act, they can't bring it. because it's barred by the ministerial exception. If they want to bring a case against you based on ethnic origin under Title VII that's not religion, they can't bring it. And that's the important thing. Brian, it's a good thing you did interrupt and talk about the important thing about the First Amendment is because the ministerial exception is grounded in the First Amendment. So what does that mean under Title VII? That says, Title VII says an employer can't discriminate based on race, sex, religion, color, or national origin. Sex also includes gender identity and transgender status under a recent case of the United States Supreme Court. It's called Bostock. And it's also, as Brian mentioned, we have state statutes too. So if you have, if someone qualifies for the ministerial exception, then the employer can discriminate on all of those things I just stated. And that's, we're not avoiding dangerous topics, but those are dangerous topics that the ministerial exception allows under the First Amendment a religious organization who has a minister exception to discriminate on all of those bases. And that is, I think it helps ministerials. So as Brian said, it doesn't just apply to clergy, pastors, and ministers. It's been broadly expanded. So,
all right, now we're getting, I think, into a lot of, the really, not that this isn't interesting, but I think what we've talked about, but hope it's interesting, but what we're getting into now is, I think, some of the real nuanced areas that I think are, not just for lawyers, but just culturally, a lot of the conversations that you're probably having. And I think it hits to your question about some businesses. Who here is, remember, you got to go back a couple years, but the Masterpiece Cakes case. Anybody not familiar by going, what's Masterpiece Cakes? Well, a cake shop, and this goes way back to 2012. The case was in 2018, but these cases always take, and this is another kind of point, legally speaking, it takes a long time for these things to wind their way from maybe an investigation by a state entity to the U.S. Supreme Court, if it makes it. So often there's a lag there because of that. Well, in 2012, Masterpiece Cake Shop and the owner / baker, again, kind of a closely held, he was the owner, he had employees, but he was the owner and he was the principal cake baker. He declined to sell a wedding cake to a same-sex couple. He told them that he would sell a cake he would certainly be willing to sell them a birthday cake, a party cake, but he was not going to sell them. It went against his spiritual beliefs. Yes?
That he designed.
Well, that gets, there was actually a little bit of a dispute about that even. The same-sex couple, they presented it and the Colorado Human Rights Commission that it was just any cake. But there was also an issue whereas he brought up, about designing this particular cake as opposed to being an off-the-shelf cake. Well, the couple filed a charge with the Colorado Human Rights Commission alleging that the baker's refusal to violate state, violated the, state anti-discrimination laws, which prohibited discrimination against based on in public accommodations, in other words, businesses that sell to the public, based on a litany of things, including sexual orientation. Supreme Court took up the case in 2018. Found in favor of Masterpiece Cake Shop, actually by a fairly wide margin. This was not a straight down the middle conservative liberal split at the Supreme Court. It was a 7-2 decision. And we're going to get to why. But they ruled that the Colorado violated the cake shops and the owners' First Amendment rights based on showing religious animus. And that kind of short-circuited what otherwise might have been a really interesting case on this topic. It was interesting, but it short-circuited covering a lot of issues. Colorado the large, the significant Supreme Court majority found did not act neutrally. That's the key principle, as we talked about before. Just like employers, government has to act neutrally with respect to religion. There was another case, for example, where a state said, oh, we are going to give these grants to schools to put new playgrounds in, but not religious schools. The court said you can't do that. You have to act neutrally. Same principle here. Well, here, and it really, as an employment attorney, really was shocking to me. The Human Rights Commission, there was emails as well as even public comments from commissioners. One commissioner stated that the baker's religion was despicable and had no place in the public and should be wiped out of the public square. And that was enough right then for the majority of the Supreme Court to rule that they violated, they didn't act neutrally, so we don't have to go any further than that. And so the court left open a lot of questions. They left open the question of how the intersection of the non-discrimination laws and free exercise would have played out without the backdrop of this. And again, I'm not saying this I'm not opinionizing, I'm not making an opinion here. These were very negative comments they made about his faith publicly. And what would have happened in this situation if they hadn't existed? To your question, to your point, how far does free exercise protection go with this? This gets to the widget question. Would it be any service if you're a religious organization, a Christian business or a religious business? Because obviously this doesn't just apply to Christian businesses. But is it any service? Would it have been a violation of the law for him to refuse to sell just a white cake that he's putting out, I need 15 white stop cakes in the front? Or does it have to be something unique or creative? Even within unique or creative, is it simply enough if he has to create this cake specifically for the wedding and it's kind of just a generic wedding cake? Or does it have to be a situation where they're requiring him to put a message, for example, for example, to do, you're going to do a wedding cake for me and you're going to put love is love on the wedding cake. Does it have to be that far? And the court said, plurality of the court recognized this was the next battleground. But courts, and it can be maddening sometimes, but one thing federal courts, and particularly the U.S. Supreme Court, historically, has always been very cognizant of, is not legislating and not going any further than they need to in deciding a case. So they said, look, 7 justices said, look, it's been the law a long time. This isn't breaking new ground to say, you can't be hostile to religion. Right. You were hostile to religion. So they sent it back down. And obviously it hadn't gone away. There's been more complaints against the same baker that have been filed. And this same case, or not same case, but same circumstance may wind its way up. Yeah, let's see. Go ahead.
So
I want to get everybody, but go ahead. Yeah.
So then we know that, Satan has certain organizations that promote his agenda in the circuit, right? Without naming any more specifically. And they target Christian companies and organizations to try to get these cases
correct.
So they could shut down these businesses. So once it's uncovered that, for example, with the baker, that he was operating within his rights and all of that, is there room for a countersuit based on defamation of character or slander because of the impact of it?
That is a great question, and it's one we get from a lot of clients in all aspects. Unfortunately, generally the answer is no.
Right.
Yes, defamation exists, but the problem is a situation like this, if it's going to be, there's no basis for a countersuit on simply bringing a charge of discrimination. That's going to be protected activity. There's also no claim based on opinion.
Right.
And often in these cases, the reason you don't get a basis is because you have a combination of things that are factual and then opinion. He refused to sell a wedding cake for a gay marriage. That's a fact.
Right.
And the comment, and that's not from, again, I'm separating, not from the government, but from the individual making the complaint. And I find that abhorrent, and he's a bad guy. Well, that's their opinion. And you can't base a defamation claim based on opinion. So the reality is, that's why it's a very effective strategy, often because there really isn't a basis to kind of recoup, your expense and things like that. I mean, I would love to say there's a whole I represent employers, so I would love to say there's a whole statutory framework where we could kind of, where there's a claim that we're successful at, kind of get our pound of flesh. But the reality is normally you get, congratulations, you won your case,
Yeah, but in that case,
Yeah.
the reason why I said slander
Yeah.
is because they said that he wouldn't sell them a cake.
Yeah.
The fact was, he wouldn't sell them the cake, that he would have to design.
Right.
Right.
And that's exactly, and that was, and the case mentioned that, and that was, the case mentioned the factual issue there, because certainly they tried to make the claim as broad as possible. In other words, don't set foot in my door, know. Whereas his position was, I will sell you a cake, any day of the week. I'm just not going to sell a specific cake for a gay wedding based on my religious beliefs. And ultimately, I think the court might have had to resolve that issue. It kind of goes back to our first question, would have had to resolve the issue of, one, even if they were even if they were accurate, even if they were telling the truth, that, the people making the complaint that he wouldn't sell them any cake. Does that matter? In other words, or would that still provide some, his, protections? Or is the battleground something more unique about, being forced to design something? Because Colorado, the Colorado's position when they ruled against him, when they found against him was, the order coming out of the Colorado Human Rights Commission was, you have to, any product that you would sell to a heterosexual couple, you have to sell to a homosexual couple or a gay couple. That was the ruling out of Colorado. Go ahead.
Well, we have
Yeah.
the guy in the
Sorry,
back
go
has
ahead.
had his hand
Sorry,
up for a
thanks,
while.
Robyn.
Actually, in the Supreme Court filings for the case,
Yes.
they were very clear, and it was actually really pivotal. And the Department of Justice filed a brief supporting the baker and drew the line
Yeah.
more clearly, where creativity was key.
Yeah.
That was really, really key. And they actually conceded that they would have had to sell a pre-made cake that wasn't touched off the shelf.
I think so.
And Bernard Stutzman, the florist, said the same thing.
Yeah.
If you want to just come and buy pre-cut flowers from my shop, you can do it. I don't want to make an arrangement for your wedding. And they used the line of cases where, if you're Jewish, you don't have to paint a picture of Hitler for a portrait painting.
Yeah.
And when I was asked a question about this case from a local government that wanted to side with the cake maker, I said, you have to be careful, because if you end up saying that the plaintiffs here are right and the cake maker's wrong, do you want a black rapper to have to write rap for an alt-right group?
Yeah.
And it really got down to the creative thing. They really conceded that the pre-made stuff they would have to sell to anybody. But it's that line of cases where if you're using the creativity, that's you get their protection.
And that's where I think this ends up. I wanted to make clear the court didn't say that. I'm always kind of careful, when I'm kind of opining versus when I'm telling you that the U.S. Supreme Court has ruled X. While the Supreme Court didn't reach that issue because they didn't have to, that's what I think. Because, there's a long line about, honestly, as we were saying in reference to a whole other legal issue, it almost comes down to kind of involuntary servitude issue. And so I think that certainly, what I speculate, and this is just kind of my belief based on someone that studies this, is ultimately where the battlegrounds is not going to be okay, you don't have to provide any services whatsoever. What I think the battleground's going to be is how unique or creative. In other words, is it, okay, well, if they just want a plain wedding cake, is that, but you have to make it? Is that violate your rights? Or does it have to be something that explicitly reflects, what you have opposition to on the cake? And I think that's going to be the nuance, because I agree. I think it's, I don't think the line's going to be providing services at all. Okay, right? Okay. Let's
Okay.
See. Yeah.
I
Yes.
just have a quick question.
Yeah.
Am I understanding what you initially said? Does this not apply to me because I have 11 employees? Is none of it like?
Oh.
Nobody's.
No, it does apply to you.
Okay.
This is, the cake, all right,
Yeah.
well,
Yeah.
all right, 15 employees, there are all sorts of rules out there. Title VII requires you to have 15 or more employees, but you're going to find out in a few minutes that you're covered. If you're not covered by Title VII, you're going to be covered by a Virginia statute that covers less than 15 employees. But the cake
Yeah,
case
sorry.
doesn't matter how many employees you have.
Yeah.
The cake case is about a business and the services that the business provides to
Right.
customers. And that has nothing to do with how many employees you have. So,
Right. And it also kind of gets to the point of question about business entities. Because there you had a very small business, it wasn't a large public corporation. You also had really the duality. I mean, yes, the cake baker was wearing, his name is, anybody remember his name? It's on the tip of my tongue. Jack, yeah. Well, I'm not going to put you on the spot for that, but he was the owner, but he was also the baker.
right.
And so that's the other aspect of this, exactly how broad it goes. Yeah.
His logo or whatever was of an easel, where it's like a painter's easel. So he really put a lot of creative energy in his work, which strengthened his case.
Absolutely.
Yeah, a lot.
Absolutely.
So,
So our next is this beast we talked about at the beginning. We talked about the First Amendment, and I told you it didn't apply to private employers, and now I've showed you that I didn't really lie in the beginning, because it does get its way through there and get rooted in. Then we talked about Title VII, 15 or more employees, and that's a federal statute. Here's another federal statute. The Religious Freedom Restoration Act of 1993, and Brian explained its genesis in the beginning when we were talking about this statute. It is rooted in the First Amendment, but Congress defined religion to be broader than to cover all sorts of religious services. And we don't know what's going to happen with this statute. We see what's happened with it in one case, but there's a lot of ground going forward with it. So what does it do? This statute prohibits the government from substantially burdening religious exercise without a compelling justification. And one of the reasons this statute happened was there was the Supreme Court. For years, this had been the law. And when those of us who went to law school, you heard about Wisconsin versus Yoder, and that the government, in order to interfere with someone's right, had to have a compelling state interest. And then that compelling interest had to be the least restrictive means possible of interfering with a person's religious right, or you violated the First Amendment. And the Supreme Court did away with that concept, and Congress came back and said, no, you're not going to do away with that concept in 1993, and passed this Religious Freedom Restoration Act. And so it applies to facially neutral laws. It's not just designed to apply to a law that's intended to violate your religious beliefs, but a facially neutral law. And so the test is, if the government substantially burdens, can I have the little thing? I like
Yes.
to do those
Yeah.
lights
Yeah.
instead of my fingers if
Yeah.
I can do it. If the government substantially burdens a person's free exercise of religion, that person is entitled to an exemption unless the government demonstrates that the application of the burden is in furtherance of a compelling governmental interest. And you can sort of see this. May come up in the concept of the COVID vaccine. Is there a compelling governmental interest to prevent the spread of COVID in the midst of a pandemic? And is this the least restrictive means of furthering that interest? So where did that come up? It came up with Hobby Lobby stores. If everyone remembers that happened back in 2013. Congress passed the Affordable Care Act. And under the Affordable Care Act, there was a mandate for free that any insurance you provided, the employer provided, had to provide free contraception, and that contraception included some that were not just preventing pregnancy, but I think there were 4 different types that would actually be seen as an abortion. And so the Green family owned Hobby Lobby. There were 2 other entities involved in this, but the Green family was a very religious family. Their corporation had grown fantastically, and they also had a Christian bookstore, Mardell, I believe was the name of that. And they were based out of Oklahoma, and they objected to the ACA's requirement. They were a large employer. They met the definition of large employer under the ACA, more than 50 employees. And if they refused to provide this mandated contraceptive methods, they would be subjected to substantial penalties. And so the United States Supreme Court looked at the mandate under the Religious Freedom Restoration Act. And one of the arguments under that act, which I think is important to us, is that the act was designed, what HRSA argued was that the act was designed to cover persons, and a corporation couldn't be a person. And so the importance of the Hobby Lobby case is the United States Supreme Court found that the mandate violated RFRA and found that corporations are persons under RFRA. Now, their definitions of corporations, though, it was a closely held corporation. And that's the important part. They held closely held corporations. A corp was protected by RFRA. Now, I don't know if they would, because the key here was that the Green family were the owners of Hobby Lobby, and that was their religious beliefs. And so that was a key to this decision. And a publicly held corporation they may still be a person under RFRA, but I don't know that they'd qualify for the exemption under RFRA.
That's actually where I come down on the Chick-fil-A question. Because clearly what Hobby Lobby teaches us is it's not just small. You know, and again, I don't want to confuse things. This came out before Masterpiece Cakes. But, you know, it's not just, Hobby Lobby stands for, it's not just a Masterpiece Cake situation where it's baker owner, you maybe have, you know, as a few people, you know, 2 or 3 employees, that sort of thing. So we know from Hobby Lobby that it can be, you know, large, successful corporations.
Right.
Where I come down on the Chick-fil-A, from a legal standpoint, is I think if Chick-fil-A had remained private, you know, when did Chick-fil-A go IPO? I mean, gosh, 2007, 2006, something like that. Before that, maybe before that. But I think that's where the switch happened. I think if Chick-fil-A had still, you know, was still owned by the Katie family. Chick-fil-A. Who owns Chick-fil-A? What? Kathy. I said true. Yeah, Kathy. They still own it. Well, but it's public. No, it's not. Oh, yeah, Chick-fil-A. No. Yeah. No, Chick-fil-A. You're right. Chick-fil-A is still private. Yeah. Thank you. Yeah, think they might have an argument as a public. I was confusing them with another entity that I talked about. I'm trying to remember which one went. I'm thinking went IPO, but no. If I think as a private organization is going to depend on whether they meet the other requirements. But I think that for Hobby Lobby, I mean, we do see that as a large corporation. That as a large corporation, you can still potentially get these protections under certain circumstances.
So it's a very broad tool, not widely known, but because 93 was not that long ago, even though it was in some senses. We will talk about how is this going to impact the future, because now we're going to turn to Virginia laws. And Brian, you want to start with this one, and then I'll take.
All right. This, if it wasn't for COVID, would have been this. If it wasn't for COVID, would have been the same. Would have been what everybody was talking about last year. But we were all trying to figure out when the economy was going to get rolling again. We were all trying to figure out, what was going to happen in this unprecedented time. Well, during that time, the Virginia General Assembly, and of course, none of this is intended to become a political conversation, but with employment, you can't ignore the politics because it drives often the law. And what we had is a big change in the Virginia General Assembly. It switched from Republican to Democrat, a few years ago. And then, of course, we still had, statewide, a full Democrat ticket. In fact, there were no statewide elected Republicans at any level in Virginia. And with that switch, one of the key agenda items that was really promoted by the Democrat Party, by constituencies within the Democrat Party, was dramatically expanding civil rights protections, and more specifically, the ability of somebody to make a claim. For pretty much our entire careers, employment law in Virginia has been federal law. Because, as one of my colleagues, Wade Anderson, likes to say, the juice wasn't worth the squeeze when it came to bringing a state claim. Because, in theory, you can make a complaint to the Virginia Human Rights Commission, but basically it would be like, oh, you're right, fix that, here's a couple weeks' pay, and, you didn't get legal fees, it was just, it wasn't worth it. The real money, particularly for your lawyer, was filing a big federal claim. So what the Virginia Values Act did was it added two things, new protections, and the headline was that it added sexual identity and orientation to the law. Honestly, for us, that was really kind of not big news because we already had a U.S. Supreme Court case, the Bostock case.
But Bostock came after.
Yeah, it came after that.
It came after.
Yeah, and it was expected. That was what was going to happen there. Where, for employment lawyers, we really saw the big change was the ability to bring these claims in state court, get real damages for plaintiffs, including things like punitive damages.
Yeah, and also, to our friend's point back there, it covers employers employing less than 15 employees.
Yes.
Prior to the passage of the Virginia Values Act, employers having less than 15 employees and more than 5 had, I think you were limited to 1 year of back pay.
Yeah.
It was very limited remedies. The gates blew open when this law was passed. So now things that we would tell smaller employers, you don't have to worry about so much, you have to think about it now. And the remedies there is some limitation on discrimination for smaller employers, discrimination in the form of harassment, but wrongful terminations, the remedies are going to be the same.
Yep. It's kind of wide open. And we haven't had claims yet because they're still winding their way through the system. And obviously COVID also kind of slowed a lot of that down, I think. So we can't sit here and tell you with certainty how these things play out, because this is new for everybody. State court judges in Virginia normally don't handle employment discrimination cases. I mean, it's not something they're familiar with. You know, non-competes, contract claims, you know, that's in their bailiwick, but not these sort of discrimination claims. And you know, large damage awards potentially. You know, so that really, I think, is a much bigger, you know, in terms of how it affects your business. I think it is a much bigger change than even some of the protections that have been added.
Yeah, there was a $50,000 initial fine that's available under the statute. It created a new section of the Attorney General's office where they can bring some of these.
Yes.
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 And we're seeing that.
And there was a state and a federal court challenge to the law that the Alliance Defending Freedom brought
Yeah.
with them, but they were premature. And one of the judges, I think it was a state court judge, even said this is probably unconstitutional, but they haven't been harmed yet. And so, which means this is really alive and well for anybody to use right now. So.
Yeah, no, absolutely. And, you know, that's just on the administrative front, but that's correct. And we haven't seen a lot of employment actions, or really any, to my knowledge.
I haven't seen any.
Well, I was going to say in the Attorney General realm.
Right.
What we're seeing where they've started actually has been with housing in this stuff. I mean, there's a couple, I've seen some press releases. I know there was one, I think a apartment owner in Newport News that they went after someone in Richmond. You know, it's not employment, so I didn't, you know, follow it as closely. But so discrimination in employment, obviously that's what we're focused on, is unlawful discrimination practice for an employer to fail or refuse to hire, and I'm not going to read all this word for word, but fail or refuse to hire, discharge, or otherwise discriminate against an individual. And here, now in 2021, this is actually pretty similar, you know, this is actually relatively similar to Title VII, particularly with sexual orientation, gender identity. It does include lactation, military status, you know, that aren't included in Title VII. And then age, of course, is its own federal statute, and the medical conditions under the ADA. You can't limit, segregate, or classify employers or applicants in a way that would deprive or tend to deprive any individual of employment opportunities or otherwise adversely affect an individual's status as an employee because of such individuals. And once again, we have the protected criteria. Again, very broad, you know, very broad language. And the important thing I think that we keep reminding ourselves as an employment lawyer is our brains go, when we read things like that, to Title VII. Right. You know, it's what our brains go to. But the reality is, you know, this isn't Title VII. And federal law generally creates what we call a federal floor. In other words, if any sort of, you know, you can't go below as a state. You can't offer less protections than federal law, but you can offer more. And because of that, you know, one thing I've been very careful when I do talk about this in presentation is, you know, sometimes not going, oh, here's what this means, as if we're sure, because what I'm really telling you is here's what this means under Title VII. But we're not talking about Title VII.
And there's a big point here that Brian made earlier. He said there's no individual liability under Title VII. There's a question of individual liability under the Virginia Values Act.
For managers, owners.
And supervisors and owners, which that's a big issue and a big problem. And I'm dealing with one right now. Someone's making a claim. Well, I'm making this claim under the Virginia Values Act too, and you got two people who may have personal liability. And you know, it's something to think about. But as Brian said, these cases have not been litigated. There is a religious exception, but we don't know what that means either. All right, read those words because nobody's interpreted those words.
Yeah, I mean, I don't read slides, but
Yeah.
we'll read this just
Yeah.
because, exception for the employment of individuals of a particular religion by a religious corporation, association, educational institution, or society to perform work associated with its activities.
So I can't tell you that I know for sure what that means. I know what I'll argue that means, but I can't tell you for sure what that means right now. Yes.
Yeah.
So what's the statute of limitations if an employee felt they were discriminated or terminated? Is there?
This went into effect July 1st, 2020, and they still have only 300 days
Yeah,
to
they still
file
have-
a charge.
yeah.
And
Except for
Lactation.
that you have 2 years for that.
Yeah.
Mm-hmm.
Without, you don't have to file a charge first for the lactation. But, so actions occurring after July 1st, 2020 are covered by this statute. Brian, you want?
Yeah, go ahead. A question?
So, yeah, the question that I have on all this is kind of the collision, you might say, of coercion. And, as a business, which is, we've gone from being very small to now approaching that 100 employees in multiple states and a number of different locations in a retail environment. And we've made a determined effort in how we structure our vision, mission, and values, that it doesn't specifically, use God or anything. In one of our values, we reference Proverbs 18:9, that slack habits and sloppy work are as bad as vandalism, but that's not, it's not overtly
Right.
Christian or anything like that. And one of the requirements of our employees is that their success is based on their embracing our vision, mission, values. And so we want to keep it so that we're not coercing somebody to do
Right.
something that would either be hypocritical on their part or exclusive to those with a Christian belief. So where, to me, the point becomes is when I, as a Christian, am being coerced to do something that's opposed to my belief. So if somebody is, one of our values is radical integrity. So if somebody is a man or a woman and wants to be referred to as something other than that, then to me that's a collision of values, and I'm being coerced to do something opposed to what I believe is true. So where does all that,
That is what I danced around it earlier, and I said there's the elephant in the room. That is the question that I don't have a good answer for you right now. I can say that if that would have to be clearly part of a closely held corporation with the owner's personal values. Does that have to be in your statement of faith that you find that opposed to your beliefs, that someone gender identity is an issue? That is a very volatile question right now. I wish I could 100% tell you the answer, because the religious exception here, and even under Title VII, is for individuals of a particular religion, but is sexual orientation religious? You're saying it is, someone else says it's not. That person with the sexual, orientation would say, well, I can sign, I believe in the Apostles' Creed. I'm a Christian. I go to church every day. It's not contrary to my values. That is I think, and Brian's shaking his head.
No,
at me.
I'm not disagreeing with you.
But,
just
but
thinking
I
about
think it's a really tough question that you've asked, and there may be a collision. Do you have to, and so that goes earlier where I also danced around the question about what you put in your statement of faith. Should that be in your statement of faith so it's clear that that's part of your clearly held religious beliefs? There's danger in doing that too. So it's, I wish I had 100% answer to tell you that if you take that stance, you're going to be protected under this exception under the Virginia Values Act, and you're going to be protected in that exception under Title VII. I think, and Brian will probably mention this too, is REFRA may come in there as well, because REFRA, and we're going to talk about that.
Yeah.
We're supposed to be talking about that in a few more minutes, but REFRA opens the question of, is this a compelling interest of the court, of the state, that they, and is this the least restrictive alternative to require you to employ an individual who you say disagrees with that individual's expression disagrees with your faith or conduct, requiring the reference to him or her to him as a him, or him as a her, or an entity as a they. Those are, I mean, that's what we're faced with today.
I guess my question to you as attorneys, to us as business owners, where I try to make a distinction is, I've erred on the side of danger of being,
And you can do that.
Yeah.
This is who I am as a Christian.
Right.
Okay. So it's like, I hope you're okay with that, because that's who I am. And even sometimes pre-employment, like we have a very diverse workforce, but just so you know, this is who I am.
Right.
Do you have any issues with that? Just to make sure that you're going to be comfortable in this environment, and then creating an environment that allows advancement of people that disagree dramatically with our my own beliefs and even those of my sons. But it's just that part of it to where it becomes a thing of me having, and we got into this. This is potentially an issue with our franchisor, who's the president, very much a professing Christian, but very much an advocate for the LGBTQ agenda. And we had a conversation in my office, and I said, you see that our employee base is very diverse, but if you're asking me to endorse something or promote something that's opposed to my beliefs, that's where we're gonna part ways, and it was a good conversation. But anyway,
and
I just love to have your thoughts on that as to how that.
Now that's, Brian, you want to go ahead? And
I think that these are going to be cases, and I think that they're going to be highly factual cases. While I can't answer this emphatically or kind of, put the final answer on this because we don't have one any more than Robyn can, I think that we're going to have a lot of cases, and they're going to go in different directions because they're going to be very fact specific. I think, without knowing how a court's going to roll on a case that hadn't happened yet, that there's going to be a difference between forcing someone, say, to use a pronoun that you object to, as opposed to perhaps another case where it's about somebody, I'm insisting on calling you by the pronoun you don't like. In other words, going, I won't refer to you as a woman, or use feminine pronouns if you're a biological male, as opposed to I'm going to insist on calling you using biological male pronouns. Exactly. Right. And those are those are different questions. They're narrow, and I think a lot of it could come down to this because I just don't think that the courts are going to say that as an individual you have to affirmatively make statements that violate your spiritual belief, or you're going to be in trouble for discriminating. But I think
I don't know.
Yeah, but we don't know. Robyn's point. That's why I hedge so much by saying we don't know.
Yeah.
But I think that's going to be the issue. But then even if that is the law, which is we don't know what I just said, then how much is that? Is it and I can use the pronoun I want to use? Or do I have to just dance around the issue with this person? And, one practical pointer, and this isn't a non sequitur, but, we're also, while this is a intellectual conversation, also try to provide some practical pointers. With Virginia Values Act, make sure, take a look at your employee practice liability insurance limits. Coverage, does it cover individuals? Does it, what are the limits? And I would do that sooner rather than later, because while I haven't seen this, my understanding is there's a lot of discussion among the major carriers going, do we even want to offer EPLI coverage? It used to be kind of a cheap, I mean, not cheap for you, but I mean for the insurance company, most of these are small, you have an EEOC charge, we pay $2,500 to make it go away, there's a $500 deductible or a $1,000 deductible, we pay $1,000, it happens once every 3 or 4 years for any particular employer, is good business. Now they're looking at going, individuals, no limit on punitive damages for some of this. So I would sooner rather than later, I'm not an insurance agent, I'm not the one to advise you on that, but, get with your broker, get with your insurance company, and just really, figure out what protections you really have in that regard. And to the extent that there's an opportunity to lock something up, I'd do it sooner rather than later. But go ahead.
And I wanted to go back to your question, because you've presented more facts, and this is why each one is, the facts are really critical. You're a franchisee, and you and your franchisor disagree on this, may disagree. I mean, I don't know whether you do or not, but you had a good conversation. Well, that opens up a whole question of, what do your corporate documents say? What is, and how can you legally defend your position? And it becomes more complicated when you have a disagreement over that particular issue. And that's what I was talking about, mission statements and boards, and entities. You have to look at, let's make sure everybody agrees, and because you've got to have that to support you to be able to take advantage of exemptions. And let's move on. Now, here's another one that Virginia just passed, and this is non-discrimination in places of public accommodation. And we all got used to the ADA and the federal laws that said you can't discriminate against individuals with disabilities in public accommodations. But Virginia has applied its public accommodation law to every protected category, including religion. And the exceptions to this one are really troubling to me, because it says the exceptions are provided for a private club, a place of public accommodation owned by or operated on behalf of a religious corporation, association, or society that is not, in fact, open to the public.
This is very troubling, I think, in terms of understanding.
Or any other establishment that's not open, in fact, to the public.
Is this now, just for clarity, this is still the
Virginia law.
Yes.
Yeah. Virginia law. So we've talked about Chick-Fil-A a lot. Chick-Fil-A is open to the public. So it can't take advantage of the religious exemption here. But what does it cover? I don't think it covers employment. I argue that it doesn't cover employment. Question whether it covers employment. But to me, the argument here is that would apply to your customers who come in, not to your employees. Or more problematic, though, students, generally colleges and universities, daycare centers are considered places, elementary schools, public and private, considered places of public accommodation because they're open to the public, although you have to fill out an application to come to be admitted. Does this now broaden the impact on these entities? We just don't know. I don't know.
And even for private organizations. I mean, in the ADA context, a big question, for things like public accommodations for disability, big question is, we have a private club, but, we thought a great way to, I have a client, I have clients that deal with this. So we have a great way to make a little extra money. We're going to be open for restaurant week. I think we've seen a lot of private clubs. We're going to be open to the public for restaurant week. I mean, does that window than make you open to the public. And, what does that mean for something like this?
Right.
Buddy?
I just had a thought, Brian. I'm wondering, we've talked about mission
Yeah.
statements regularly. So I'm wondering if the inclusion in one of their business owners' mission statements could be something to the effect in explaining their faith, that there is a commitment to the authority of Scripture as a part of their mission statement. And if that's the case, some of these issues at least can be strongly addressed.
They can be
You
argued.
can debate some.
Yeah, you can
But
debate.
Could you include that in the mission statement for a business?
Oh,
Sorry?
you certainly can. Then the question's going to be, but you are, on this part, if you're a business and you're open to the public, you can't take advantage of that exception. And if you go back one slide, Brian, to the exception here, it says work associated with its activities. I want to interpret that broadly. I want to say it's like the Supreme Court, any activities on, like Title VII, it's any activities of that entity. You can take advantage of that exception under Title VII for employees. But the answer's not 100% clear. And Brian, let's round this up.
Yeah, that's what I'm thinking. Where do we go from here? This is kind of the wrap up, and this is a great chance to kind of talk about these issues. Our discussing these is the battle lines and just something that we're reading. The Supreme Court hasn't hid this. The Bostock case doesn't really come in, doesn't really directly come into play to what we're talking about. But where is interesting, and of course that's the case that where the court recognized that Title VII, the application to sex, discrimination applies to sexual orientation and sexual identity. Justice Gorsuch is the justice that wrote that opinion. What I think in terms of a lot of the public media has been lost is, and perhaps why Justice Gorsuch said, I'm going to take this one. This quote, because RFRA operates as a kind of super statute, displacing the normal operation of other federal laws, it might supersede Title VII's commands in appropriate cases. And that was not an issue in Bostock, because another comment from Justice Gorsuch was, in the lower court, you raised RFRA, but you didn't preserve it on appeal. And you didn't continue with that argument, so it's not before us. So he is absolutely recognizing that this is going to be the battleground of an employer saying, wait a minute. In that case, it was a funeral home, but they didn't raise the issue, as Justice Gorsuch said. Where is that, that tension? The state says, oh, you can't discriminate based on sexual orientation, or something along those lines. The employer says, no, we don't recognize this, and we think under RFRA, that is our right. The state may say, well, RFRA's, federal, and, you're pulling stuff from Title VII. This is our state law. But that's where your review said this is really important. Is the court going to say, but no, all this is rooted in the First Amendment, is where we get this from. Robyn and I were talking, it's interesting. Most other countries, when you look at their anti-discrimination laws, they protect religion, but it's more of a standpoint of, for example, you can't fire this. Usually, you can't fire this guy because they have a minority religious opinion, or something like that. Not this accommodative, like we were talking about before. The reason we have that really stems from the First Amendment, even though businesses doesn't apply to businesses, as we talked about. So much of the framework here comes from the First Amendment. So these are, some kind of wrap-up final questions, or kind of to bring this thing home as we promise on time. Some questions. How will courts decide conflicts between free exercise and enforcement of non-discrimination laws when they conflict? Which of these will take priority? It's just as Gorsuch said, does RFRA trump Title VII? What extent will the religious protections apply to businesses and entities? We know there certainly exist, as we saw, but back to the Chick-Fil-A question, which I appreciate that. I was answering on a whole nother topic on Krispy Kreme on something else, and I had Krispy Kreme in my head when I was talking about Chick-fil-A, so thank you for that correction, by the way. But how broadly will it apply? Will religious exemptions that apply in Title VII apply to the Virginia Values Act, just to bring it home to us? And then finally, elections have consequences. Certainly we wanted not turn this into some political argument, or anything partisan, this presentation, or make this hijack our religion presentation into an election wrap-up. But again, you can't do employment law and try to we ignore the elections as if they don't have direct consequences. We have a new governor. Even more importantly, we're going to have a new attorney general. And we don't know what Attorney General-elect Miyares' enforcement priorities are going to be, but I don't think it's a stretch to say they're probably going to be different than Attorney General Herring's. I mean, I don't think I'm saying anything which is like, okay, you believe he said that? That's shocking. And also with COVID and other things, so much of what we have comes from executive order. There's been some action by the General Assembly, and the Virginia Values Act is a law. So, Governor-elect Youngkin, when he takes office, can't say, well, no, we're not doing that. But so much of these other issues are, kind of, what was it? I got a phone and a pen. President Obama said these are phone and a pen kind of stuff. So, these are the battlegrounds, and, I'll turn things over to Robyn, but I really think, it's a great idea as any to talk about this. Spend the few minutes we have left here, 3 or 4 minutes.
I don't think we have any left.
Well, I know we started a little late, so all right, yeah. So,
we have 5 minutes left.
we appreciate, it, Robyn. I'll turn it over to you, but we're certainly happy to answer any questions. We want to be respectful of your time, so we'll kind of wrap it up here from a formal standpoint. But Robyn and I aren't racing out the door right this second either, so. But.
Well, I do want to thank you all for having us, and Brian did wrap it up with where do we go from here. So I hope you found this interesting. We've given you some answers. We've given you a lot of I don't knows, and I wish that I could tell you here's the litmus test, here's the bright line. But let's take solace in the fact that we live in a country where we don't necessarily have bright lines, because sometimes the bright lines can be drawn the wrong way. So right now, I wish that I could tell you this is what you do and that is what you do. We're in a new frontier, and it's interesting. The First Amendment is still there. RFRA's there. Title VII's there. Virginia Values Act is there. And there's a collision course that may come about, and we'll watch and see, and who knows, Brian and I may be participating in one of those.
Yep.
But yes, sir.
Yep.
I was just going to say that I thought you brought a lot of clarity, so I didn't mind the unanswered quote questions at all.
Well, I think we're not doing any service. I think Robyn and I, neither of us are scared to say we don't know. I think sometimes people, say, well, I don't want to say that. I might not look like an expert. But, it's as important as business owners, and we adopt this in our own practice, like when we're counseling clients. It's important to bring up the areas that you don't know for sure. There's value in that, in raising those issues as well, and not just kind of going, well, this is the wheelhouse. Here's where let's just steer the conversation to where there's bright line answers. Because as a business, you have to prepare also for the unknown. And sometimes there's not here's the answer, but the more information you have, I think the better you can prepare. So even though we haven't been able to answer all your questions, hopefully we've given you more intellectual ammunition that as you're trying to navigate this as best as you can, you maybe feel you have more facts, more information than you did when you came in. Any other questions right now? And again, if anyone needs to leave, please, we want to be respectful. We'll consider this kind of the overtime portion, but we're good. Go ahead. I think you had your hand up first, and then we'll go. Oh, sure. Slide 1. Oh. Do we? Oh, slide. Yeah, gotcha. Go ahead while I'm getting back there.
Yeah, well, I just want to say, I think it's a great discussion. I'm not sure from Buddy's standpoint and Jordan's standpoint, and from Beatles' eye perspective, if this was a successful event, but I consider it, in terms of turnout, I consider it to be successful as far as my investment of time. I would love to see a follow-up in 6 months after things have settled in with the on the state level, and just as the pace of change of things and with COVID and everything else. But I did have a question specific to the vaccine mandates. And I'll state a little bit of kind of where I am. So, I'm vaccinated and I've encouraged our employees to be vaccinated. At the same time, I don't like coercion from the government to say people this is what you have to do. As a business owner, do you believe that being more liberal in terms of allowing the religious exemption, is that a dangerous thing?
How many employees do you have?
We're getting very close to 100.
Okay.
Yeah.
Okay. And, well, Brian said the rules came out
today.
Yeah. So
big caveat, we haven't read them yet.
Yeah,
we were here.
so we haven't read those yet. But, it's a real balancing act because we've been in a pandemic. Now, we do have the United States Supreme Court denied a writ in a case this week or Friday.
The Maine case.
Yeah. The state of Maine will not allow a religious exemption to their vaccine mandate. And the Supreme Court refused to grant an emergency injunction hearing. And therefore, they basically blessed, at least during the pendency of this case, not granting religious exemptions, which was sort of a surprising. There was a strong dissent and interesting issues raised. But it was only, there were 3...
the dissent justices Gorsuch, Thomas, and Alito.
Yeah. Dissented and said that this was... And they brought up issues that I don't even know if I agree with. Like, are we out of the pandemic? Has the compelling state interest subsided? How long does a pandemic go on? They mentioned emergency use authorization. Emergency use authorization, however, has been a defeated argument against the vaccine. So there are lots of issues out there. So on the vaccine, a mandatory vaccine program, it's a balancing. You've got a pandemic. We've had 900,000 people in the United States die. So you have to look at that. If you grant a religious exemption, do you make sure that you've protected your other employee populations? But as Gorsuch, and as that dissent noted, we have breakthrough cases with vaccinated people. Vaccinated people now can carry the virus and infect other people. So there are questions out there that are difficult.
When does it when does it go from pandemic to endemic? Right. And it's just something, again, not comparing the two, clearly I want to be 100% clear on this. One's an infectious disease, one's not, but obviously a lot of people die from cancer, which is not infectious as apples and oranges, other than the fact that that's kind of something endemically that we live with. Is it something at some point the flu is a good example. Is at some point, do we look at it as just something endemic versus a pandemic? What's the least restrictive means? Is there a less restrictive means?
So how does that brush up against violating the Nuremberg Code?
That doesn't apply because the Nuremberg Code, two things that don't come into play here that are often cited when it comes to vaccines. That's why we haven't mentioned them. One is the Nuremberg Code, because that applies to experimentations.
Right.
And, I appreciate the argument, saying, well, gosh, this vaccine hasn't been around, for very long, but it would not be a, coerced or forced experimentation just based on the definitions. And that's how it's been interpreted. So, and then the other, go ahead, I was going to mention HIPAA.
And also, it's important, and mention that in a minute. It's also important to remember what I talked about at the beginning. The First Amendment doesn't apply to private employers. It applies to governmental entities. If a private employer determines that they want to implement a vaccine mandate, then all they're saying is, if you want to work for me, you have to get a vaccine. The only thing that religiously impacts a private employer is Title VII of the Civil Rights Act with respect to the vaccine mandate. The First Amendment doesn't apply. The Nuremberg Code doesn't apply. Now, a bigger question becomes, when we read these regulations today, now the government has stepped in. I don't think the Nuremberg Code's going to apply anyway, because you can choose to get a vaccine or not. It's not experimentation. But
I'm speaking to the mandatory nature of that mandate.
It's a mandate if you want to work. It's not a mandate if you want to live. You can live. You just don't have. You just can't work in this place.
Just very,
you
very
can go eat. We're not going to bring you in and take your life away and strap you down and do something experimental to you.
Well, that's when it becomes a problem.
Yeah, that's what the Nazis did.
Under that law. Just talking specifically to that.
Yeah, but all the vaccine mandates are saying, if you want to work here, if this is the way you want to earn your living, then you have to comply with this. If you have a sincerely held religious belief that you are a Christian scientist, is always the easiest one for me. If you're a Christian scientist and you fill out an exemption form that you're a Christian scientist, then you're entitled to determine whether we can accommodate your sincerely held religious belief. Because you don't take aspirin, you never go to the doctor, and that's the problem with the whole fetal cell argument too. When people say they've used aborted fetal cells in the testing of these vaccines, you also have to realize they used aborted fetal cells for Advil, a whole panoply of other medications that people take every day, but there are people selling religious exemptions from California to Virginia right now.
We've seen them. I mean, we've dealt with it.
We've seen them. I actually had a client bought one to see what came in the whole package for $30. So it has to be not a political belief, but a sincerely held religious belief that goes to private employers.
Yeah, I was just going to mention also, you didn't ask about it, but HIPAA also doesn't come into play for any of this. I see that a lot on Twitter, comments about, doesn't this violate HIPAA? HIPAA, and I'm not turning this into a HIPAA lecture, but just very briefly, it applies to medical entities sharing your information, business partners of medical entities, like a clearinghouse, for example, sharing information. It does not prohibit an employer from saying, are you vaccinated? It does not prohibit a vaccine mandate, doesn't prohibit, those sorts of issues. It just doesn't. I mean, that's not even making an argument about whether vaccine mandates are good, bad, or neutral. It's Apple. I mean, when I say HIPAA doesn't apply, I'm not arguing about the mandate. I'm saying HIPAA doesn't apply the same way that, some other random law. I can't think of a good random example. Laws prohibiting gambling on, something like that also doesn't apply. I mean, it's apples and oranges.
I did have a question about a federal contractor.
Yeah.
So I have a advertising agency. I'm a Christian, so I'm also a pastor. And so now they're saying that in order to get federal funding or apply for federal grants and RFPs, you have to be vaccinated.
The whole nother mandate. Mhm.
It's a different mandate, yeah.
Or do I have any protections under that or no?
That mandate allows for religious exemptions for individuals, but it has to be sincerely, you know, they.
This is what I'm saying, I'm a pastor, we have 3 locations, so I'm really a pastor.
Yeah.
It would have to be all of your, unless, that's a good question, because you as a pastor, I mean, your company, if your company is a government contractor, in order for any of your employees to go do work for the government, they have to be vaccinated by December 8th. And so each individual employee, there's no provision for...
No, we just meet individually.
Yeah, and being a pastor isn't what his job is on his contract.
No. I understand that. I'm saying his contractor job, your contractor entity.
I'm sole proprietor, so.
There's no provision
For the entity.
for the entity to get an exception. There's only provisions for the individual employees.
Yeah. I think that's where you go with this. And
Yeah,
again,
you
I'm
go
not,
with
I'm
one
not
employee.
promising what the result will be, okay? But I think the way you go with that isn't, oh, my business isn't going to comply. It's, what I mean, I think that's fine, okay? We'll comply, and I'm exempting myself based on sincerely held beliefs.
But then you have to...
I mean, I'm not saying it's going to work for sure.
Right,
I'm just saying
because
that,
then
yeah.
your exemption has to be accepted by the entity with whom you are doing work. So if you are a sub for a prime, that prime can say, I can't, you understand your religious exemption, I can't accommodate
Yeah.
it.
Actually, the agencies are saying that.
Yeah, that's
Yeah.
not surprising. Yeah.
Right,
Yeah, in Virginia, it's just the way it is.
Yeah.
yeah,
So you just have to decide if you want to work your contract.
right.
So I should just only work for Christian companies. I should have. Yeah, okay, fine. I'll do that for sure.
Anyone else? Well, listen, thank you all again so much. I hope everybody found this interesting, because I certainly do. Thank you.